Welcome to a deep dive into one of the most significant legal battles in the publishing world today. Today, we're breaking down the class action copyright infringement lawsuit against Anthropic, the creators of the Claude AI models. This case, Bartz et al. Versus Anthropic PBC, centers on a crucial question. How can AI companies use copyrighted material to train their powerful models, especially when that material might come from unauthorized sources? Our story focuses on Anthropic's alleged use of copyrighted books, many reportedly obtained from pirated copies, to train their Claude AI. Let's trace the key events. August 2024, nonfiction authors Andrea Bartz, Charles Greber, and Kirk Johnson filed a class action lawsuit against Anthropic. They accused Anthropic of using their copyrighted books, often sourcing them from known pirate sites like LibGen and Pilimi, to train their AI, all without permission or compensation. This immediately put Anthropic on the defensive, setting the stage for a precedent-setting legal battle. June 2025, U.S. District Judge William Haskell Alsup delivered a pivotal, mixed ruling. On one hand, the judge ruled in favor of Anthropic regarding legally acquired books. He stated that training the Claude AI on these materials was transformative, and thus, constituted fair use. This was a significant win for AI developers. However, the ruling also came down against Anthropic on a critical point. The judge declared that Anthropic's mass downloading and storage of books from pirate sites was not protected by fair use. He called it, inherently, irredeemably infringing. This distinction was crucial, shifting the focus to the illicit acquisition of data. A trial was scheduled to determine liability and damages for these piracy claims. July 2025, building on the judge's ruling, the court officially certified a nationwide class of copyright owners. This included anyone whose works were taken from the specifically named pirate sites, LibGen and Pilimi, and were properly registered with the U.S. Copyright Office. This expanded the lawsuit significantly, representing a large number of potential claimants. September 5, 2025, the parties announced a proposed settlement agreement. Anthropic agreed to pay a minimum of $1.5 billion into a settlement fund. In addition to this substantial payment, Anthropic also committed to destroying its copies of works that had been acquired from these shadow libraries. September 25, 2025, just a few weeks later, Judge Alsup gave his preliminary approval to the $1.5 billion class action settlement. This was a crucial step towards finalizing the agreement. October 2, 2025, to facilitate the settlement process, a searchable list of approximately 500,000 titles covered by the agreement was published on the official settlement website. This allowed authors to check if their works were included. January 7, 2026. This is the deadline for affected authors to formally opt out of the settlement. Choosing to opt out means rejecting any award from the fund, but it preserves their right to sue Anthropic separately. March 23, 2026. Class members whose books appeared on the works list have until this date to file a claim to receive their share of the settlement fund. Payments are estimated at about $3,000 per book. April 2026. Judge Alsup will hold a final hearing to decide on the settlement's definitive approval. The Anthropic case has set a precedent that will echo through every AI copyright lawsuit going forward. Similar cases against OpenAI, Google, Meta, and Midjourney are all watching closely. The message is clear. AI companies can train on copyrighted works under fair use, but they can't pirate them. And if they do, it'll cost them billions. This lawsuit represents a turning point in the AI era, a moment when creators fought back and won. Whether that victory is meaningful enough remains to be seen. It's important to note, this settlement primarily addresses Anthropic's past conduct, specifically, the acquisition and internal training on pirated works. It does not protect the company from future claims, such as those related to potentially infringing output produced by its AI models, or claims from authors whose works weren't covered by this specific class action. This case highlights the ongoing complexities and legal challenges facing AI developers as they navigate intellectual property rights in the age of generative AI. What are your thoughts on this landmark case? Let us know in the comments below. Don't forget to like this video and subscribe for more stories on how AI is impacting the publishing world.